Hello, and a very warm welcome to this first module in our series, Navigating Disciplinary Hearings in South Africa. Over the next few minutes, we're going to lay the essential groundwork for understanding and managing workplace discipline effectively and, most importantly, fairly. This module is all about building a solid foundation, ensuring that you feel confident and equipped to handle these situations professionally. Let's begin. So, what's on the agenda for this session? By the end of this module, our goal is for you to be able to confidently understand the real purpose behind a disciplinary hearing. It's more than just a formality. We'll define the key terms you'll encounter, so you can speak the language of workplace discipline. We will also touch on the critical legal framework here in South Africa that governs everything we're about to discuss. And finally, we'll introduce the two pillars of fairness, substantive and procedural, which are the absolute cornerstones of any fair disciplinary process. You might be wondering, why is this so important? Well, getting discipline right has a massive impact on the entire organization. Firstly, it ensures a safe and productive environment where everyone understands the standards and feels protected. Secondly, it's a tool for correction, not just punishment. It helps guide employees back to the expected behavior. Critically, following a fair process protects the business from very costly legal challenges, like an unfair dismissal case at the CCMA. Ultimately, it's about building a culture of fairness and mutual respect, which is the bedrock of any successful team. You don't need to be a lawyer to manage discipline, but you do need to know the rules of the game. In South Africa, our actions are guided by a clear legal framework. It starts with the Constitution itself, which guarantees everyone the right to fair labor practices. The main piece of legislation we'll refer to is the Labor Relations Act. Within the Act is Schedule 8, the Code of Good Practice on Dismissal. Think of this as our instruction manual. It tells us exactly how to ensure fairness. Finally, the Basic Conditions of Employment Act also plays a role, especially concerning things like notice periods during termination. Let's clear up a common misconception right away. A disciplinary hearing is absolutely not a court of law. We are not lawyers, and the process is internal to the company. Its purpose is simple. It's a formal, structured conversation designed to investigate alleged misconduct. It's a fact-finding mission. The primary goal is to give the employee a formal opportunity to hear the allegations against them and, crucially, to present their side of the story. The entire exercise is about arriving at a decision that is fair and, very importantly, based on the evidence presented by both sides. To navigate these waters, we need to speak the same language. You'll hear four key terms frequently. The complainant, or initiator, is the person who formally brings the charges on behalf of the company. The accused employee is, of course, the employee who needs to answer to the allegations. The chairperson is the neutral, impartial person who acts as the decision-maker. And finally, the allegation, or charge, is the specific rule the employee is said to have broken. Understanding these roles is the first step to understanding the process. If you remember only one thing from this module, let it be this. Every fair disciplinary action in South Africa stands on two unshakable pillars. The first is substantive fairness, which asks, was there a valid reason for the discipline? It's the why. The second is procedural fairness, which asks, was the process used to get there fair? This is the how. If either of these pillars is weak, the entire structure of fairness can collapse, exposing the company to significant risk. You absolutely must have both. Let's look closer at that first pillar. Substantive fairness, the why. To prove substantive fairness, you need to be able to answer yes to a few key questions. First, was there a workplace rule, and was it reasonable? You can't discipline someone for breaking a rule that doesn't exist. Second, was the employee aware of the rule? For example, is it in their contract or the company policy? Third, is this rule applied consistently to everyone? You can't enforce it for one person but ignore it for another. And finally, is the punishment fitting for the crime? Dismissing someone for being 5 minutes late one time would likely not be considered substantively fair. Now for our second pillar, procedural fairness, the how. This is all about the process. The law is very clear on the steps you must follow to ensure the process is fair. The employee must be notified of the specific charges against them, in writing, and in a language they can understand. They must be given enough time to prepare their response. You can't notify them at 4 p.m. for a hearing at 9 a.m. the next day. They have the right to be represented, typically by a colleague or a union rep, and the right to state their case and call their own witnesses. Crucially, the hearing must be overseen by an impartial chairperson who wasn't involved in the incident. So, does every single mistake require a full-blown formal hearing? Absolutely not. It's about proportionality. For minor issues, like occasional lateness or a small, careless error, informal counseling or a simple verbal warning is often the best approach. The goal here is to correct the behavior, not to punish. However, for serious misconduct where dismissal is a real possibility, think of things like theft, assault, or gross insubordination, a formal disciplinary hearing is non-negotiable. This follows the principle of progressive discipline. You start with the lowest effective measure and only escalate when necessary. The chairperson is like the conductor of an orchestra. Their job is to control the process and ensure everyone plays their part correctly. Their single most important quality is impartiality. They must be unbiased and have no prior knowledge or involvement in the incident. Their responsibilities are to manage the hearing, make sure the process is fair to both sides, listen carefully to all the evidence, and then, based only on that evidence, make a finding. If the finding is guilty, they must then decide on a sanction that is appropriate and fair. The initiator, or complainant, has a very different role. They are there to represent the employer and present the company's case. They are not the judge. They are one of the two parties in the hearing. Their job is to clearly state the charges against the employee and then present the evidence the company has gathered. This includes calling company witnesses to give testimony and cross-examining the employee and any witnesses they may call. If the employee is found guilty, the initiator will also argue for what the company believes is an appropriate sanction. The entire process is built around protecting the rights of the employee to ensure they receive a fair hearing. The most fundamental right is the right to be heard, to tell their side of the story. They also have the right to be represented, the right to an interpreter if they can't follow the proceedings in English, the right to call their own witnesses to support their case, and the right to cross-examine the company's witnesses to test their evidence. These rights are not optional. They are essential components of procedural fairness. So how does the chairperson decide who to believe? This is a critical point. Unlike in a criminal court, we don't need to prove a case beyond a reasonable doubt. The standard of proof in a disciplinary hearing is the balance of probabilities. This means the chairperson listens to all the evidence and simply asks, based on everything I've heard, is it more likely than not that the employee committed this misconduct? It's about probability, not absolute certainty. If the scale tips even slightly in favor of the company's version of events, that is enough to find the employee guilty. Let's walk through the journey of a typical hearing. It begins with the chairperson opening the proceedings, introducing everyone, and reading out the employee's rights. Then, the company, through the initiator, presents its case. After that, the employee gets their turn to respond and present their case. Once both sides have presented all their evidence, they will each give a short closing statement to summarize their arguments. The chairperson will then adjourn the hearing to consider everything in private. Finally, they will reconvene the hearing to deliver the verdict and, if necessary, the sanction. After the hearing, there are two main paths. If the chairperson finds the employee not guilty, the matter is closed, and that's the end of it. If the employee is found guilty, the chairperson must then impose a sanction. This follows the principle of progressive discipline. It could be a verbal warning for a minor issue, which is still formally recorded. It could be a written warning, or a final written warning for more serious or repeated offenses. And in the most serious cases, the outcome could be dismissal, either with or without notice, depending on the severity of the misconduct. I want you to remember this phrase: if it's not written down, it didn't happen. In the world of labor law, this is golden. Meticulous record keeping is your single best defense if a case ever goes to the CCMA. You must be able to prove that you followed a fair process. This means keeping a copy of the notice to attend the hearing, taking detailed minutes or a transcript of the proceedings, ensuring the chairperson provides their findings and their reasoning in writing, and issuing a formal outcome letter to the employee. This paper trail is non-negotiable. Many well-intentioned hearings are lost at the CCMA because of simple, avoidable mistakes. A huge one is bias, appointing a chairperson who was involved in the investigation. Another is having vague charges, where the employee genuinely doesn't know what they're accused of. Rushing the process and not giving the employee fair time to prepare is another classic error. You must also avoid inconsistency, punishing one person for something you let others do. And finally, you cannot discipline an employee twice for the same offense. This is known as double jeopardy. Being aware of these pitfalls is half the battle. So, let's quickly recap our key takeaways from this foundational module. We've learned that disciplinary hearings are a vital management tool, not just a punitive one. We've established that every hearing must be built on the twin pillars of substantive and procedural fairness. Our actions are always guided by the Labor Relations Act and its Code of Good Practice. The goal is always corrective, and decisions are made on the balance of probabilities. And finally, we know that clear, consistent documentation is absolutely critical to ensuring the entire process is defensible. Congratulations! You are now a workplace leader. You now have the complete foundation, the legal context, the key principles, and the procedural roadmap to confidently and fairly manage disciplinary hearings. You now understand the importance of asking the why and how questions that underpins a just and respectful workplace culture. On behalf of all of us at LearnYa Skills, thank you for your commitment to fair labor practice. We're excited to see you apply these principles to build stronger, more effective teams. For more resources and to continue your learning journey, visit us at www.learnyaskills.com.